Well, good morning, everyone. I'm Anita Huberman. I'm CEO of the Surrey Board of Trade, and welcome to this morning's Surrey Digital Town Hall, focused on personal estate planning and planning opportunities with our facilitators from the law firm of Fasken. And really, we're focusing on personal estate planning and planning opportunities in light of the pandemic in which we're all in together. Still at this time, I would like to acknowledge that we are on the unceded territory of the Coast Salish people, specifically the Kwantlen, Katzie, Semiahmoo, and Tawasin First Nations. I would really like to thank the Port of Vancouver for their sponsorship of the Surrey Digital Town Hall series. The Port of Vancouver is Canada's largest port, and they are trading with over 170 different global economies. A great shout out to our frontline workers, where they are ensuring that we are getting the goods that we need, participating in our national and global supply chain. So thank you again to our marine pilots, our terminal workers, our truck drivers, and our railroaders at the Port of Vancouver. Just a couple of instructions before we begin. The session is being recorded. The link will be sent to you after the session is over, and you can share it with whomever you please. And if you do have a question for the facilitators this morning, please type your question in the chat function. COVID-19 has caused many to turn their mind and their state of their own personal affairs and that of their business. What is the future going to look like for your workforce? What is the future going to look like for your family? We all need to ensure that we have a plan in place, whether it's short-term, medium-term, or long-term. I also wanted to ensure before we begin that you are visiting the Surrey Pandemic Business Center at businessinsurrey.com every day. The links are being updated each and every day. There are new resources coming into play, especially as we look to restart British Columbia's economy. I'm very pleased to represent the Surrey Board of Trade as part of the Premier's COVID-19 Economic Recovery Task Force. And also we have formed a Surrey Economic Recovery Coalition with our local chambers of commerce and BIAs. We meet weekly with the City of Surrey Emergency Response Team. And finally, the Surrey Board of Trade has a direct line into the Prime Minister's office to ensure that on the ground, at all levels of government, we are identifying gaps and opportunities for businesses, for the economy, for our families in Surrey, in British Columbia, and in Canada. So to introduce your facilitators this morning, I'd like to welcome Annie Chen. She's a partner at Fasken, and she focuses on wills, estates, trusts, a corporate lawyer in Fasken's Vancouver office, advising clients on wealth management, estate planning, and personal and corporate tax planning. Just a wealth of experience available to you within this 1 hour that we have with you. Welcome, Annie. And then we have Eric Clavier. He's an associate at Fasken, and his expertise is really focused on trust and estate litigation, assisting clients with resolving contentious matters related to wills, trusts, undue influence, and incapacity claims. He provides innovative solutions to disputes arising from estate planning, wills, trusts, and personal documents. All very complicated matters. So let's begin. First, I'm going to have Eric provide a brief introduction and an overview of the topics that we're going to cover. Eric, over to you.
Thank you, Anita. I am unable to start my video. If you could start that for me.
Actually, you have to do it on your side.
It says the host has stopped it, so I'm not sure.
Well, you can begin talking.
All right, let me commence, and thank you for the introduction. Yes, as you've mentioned, I'm a trust and estate litigation lawyer at Fasken in our TWEC group. For those who don't know, Fasken is an international law firm. We've got offices both in downtown Vancouver and since February of 2 years ago in Surrey as well. TWEC is an acronym for Trust, Wills, Estates, and Charities, and that is essentially the group within Fasken that I'm a part of. I'm one of 10 lawyers. We have planners, we have litigators, and we have tax specialists. And my co-presenter today, Annie Chen, is a planner, as Anita mentioned. And the reason why we have a planner and a litigator here today is because we wanted to cover estate issues, both from the planning as well as from the litigation or risk perspective. I'd like to thank the Surrey Board of Trade for inviting us to participate in the Digital Town Hall webinar today. And as Anita has also mentioned, it is an topsy-turvy time in the world. It is probably good that we are at this stage turning our mind to the state of our personal affairs, whether we have appropriate plans in place for the protection of our assets and our family members in the event that we should get sick or something unfortunate should happen. But at the same time, we should also see this as an opportunity or a time of opportunity for certain estate planning issues, and Annie will touch on that later on today. But specifically when it comes to setting up trusts or implementing planning for corporations, this may be a good time to be doing that. So we want to cover as many topics as we can. We've got 10 questions that we want to address, and hopefully we'll give you a broad idea and picture of what estate planning generally is, what estate options are available to you as far as planning is concerned. And when you leave here today, you will hopefully have a plan or have some ideas as to putting together a plan that might be best for you and bespoke for your personal situation. So also finally, thank you to everyone who's joined us this morning and is participating as a member of the audience.
Thank you so much, Eric. And before we get into the questions, Annie, do you have any opening remarks that you would like to deliver?
Thank you, Anita. So I just want to thank everybody for attending. I think Eric has already provided a good overview of what we're going to be talking about today. I know we've prepared have 10 top questions that we think might give everybody a good overview of planning and in this time of COVID-19. And so, of course, we have limited time today, so we won't be able to get into a lot of the details, but hopefully we can cover at least a general idea, give everybody a general idea of what's going on, what might be available. And then if you do have further questions, you can feel free to contact Eric or myself at any time. Thank you, Anita.
Thank you so much, Annie. So Eric, my first question is over to you. What is an estate plan, and what estate planning tools are generally available to residents of British Columbia?
Thank you. So to borrow a term from IT, which is my wife has actually provided this to me, and I think it's quite useful, and it says that failing to plan is planning to fail. And so when it comes to estate planning, what we're talking about generally is the process of anticipating and arranging during your lifetime for the management of and disposal of your assets or estate, both during the period of your life and after death, while at the same time attempting to minimize taxes. There are various tools that are available to us to plan our estate and to put an estate plan together. The most basic and common and well-known one is, of course, the will, but there are many others that can go either hand in glove with the will, or alternatively are a substitute or an alternative to putting a will in place. But the addition of documents such as enduring powers of attorney, healthcare representation agreements, as well as setting up trusts is part of what we consider estate planning tools. There are others that we're not going to have time to get into today simply because we're constrained for time, but you can bear in mind that joint ownership or joint tenancy planning or designating beneficiaries are also options that can be part of an estate plan.
Annie, you know, what is really prevalent during this pandemic is the need for a will. What is a will, and why is it that people need one?
So will essentially is the simplest form of postmortem planning. So planning for when somebody passes away. And a will, what it does is it allows a person to set out terms and appointments that will cover the assets that they personally own at the time of death. So this does exclude certain assets though. So if assets are jointly owned, if assets have a designated beneficiary, and as everybody probably knows, there are certain assets by law that we're allowed to designate beneficiaries for. So things like life insurance or registered accounts like RSP, RIF, or TFSA accounts. So if you do have jointly owned assets or assets that have a designated beneficiary, then those assets will not go through your estate, will not go through your will. Okay. So now the other thing we do in the will, like I mentioned, we can do appointments. So the person, the client, can actually appoint who they want to be executor of their will. So the executor essentially takes over at the time of death and is responsible for managing all of the estates, paying taxes, paying debts, and then the distribution. So without a will, though, it does become a lot more complex. And if the client does have family members who don't agree on who should be executor or legal representative of the estate, then it could become a fight in the courts. Okay. Now we talked about distribution of assets. So in a will itself, you can set out distribution of assets, how the person wants to divide up any of the assets that fall through their estate. And one of the things that when we talk about clients about distribution of assets, and one thing they should think about are what we call testamentary trusts. So if the client does have people, beneficiaries, family members who are minors, so minor children, or any beneficiaries with disabilities, then it's very important to set up these type of trusts to hold the inheritance that could go to them in the future. It's quite vital because without these provisions, without these terms, then it defaults to the law. And under our law, all of these assets will be managed by the government, so by the Public Guardian Trustee Office. And that, depending on what the client's wishes are, may or may not be appropriate for that client. And particularly for minors, by law, if it is managed for them by the PGT, Public Guardian Trustee, when that minor becomes an adult, becomes 19, they do get full access to all the funds. They will be considered adult and all those funds will be released to them. So for a lot of my clients, they don't feel as if their children would be mature enough to manage their assets at 19. So this is where we can set up ongoing trusts that will go past the age of 19 and meet what the client's wishes are. The other thing that these testamentary trusts can do is they can provide a lot of protection for beneficiaries. So it's not just for minor children or for beneficiaries with disabilities. We can also set these up for beneficiaries who are adults, but perhaps might not be as financially savvy or responsible. So clients can set up these trusts to help protect them against themselves and set up trustees or people to manage these assets for them. The other thing that these set of trusts can provide are potential tax savings, right? Depending on how we structure it and who are the family members involved. The other thing that we can protect as well is these testamentary trusts do provide the beneficiaries with some level of asset protection. So a lot of my clients may think, yeah, my child, son or daughter, has a partner, but they may be concerned about that relationship. And so they may want to set up these type of trusts because they will help to protect for that child in the future if there is any kind of relationship breakdown. So a will, to summarize, is the simplest way of doing postmortem planning, but it's not the only way. And we'll talk a little bit about other potential types of planning. And so even if your assets are very simple or your family dynamics are very good or a simple family dynamic, having a will is still extremely important because it allows your family members, if something happens, to much more easily deal with your estate. Thanks, Nina.
So I'm really curious then, Eric, to know, does a will have any downsides compared to other estate planning tools?
Well, the will certainly does have some downsides, and probably the most prevalent is that of probate. The word probate meaning proof, and the process of probate meaning to prove a will as being legally valid. When you pass away, what happens is that your executor as nominated in the will or an administrator who wants to prove the will must apply to the BC Supreme Court to prove that the will is legally valid. And that process, unless the estate is worth less than $25,000, will invoke probate fees. Probate fees are they levied on a sliding scale in British Columbia, but generally you can work on the assumption that about 1.4% of the net value of the assets in the estate will be subject to a probate fee. Now, that may not sound like a lot, and it certainly is a lot less than it is in other jurisdictions like the UK, for example. But on a $1 million house, which is pretty much what a house in British Columbia would cost at the minimum, the probate fees would already be at $14,000 for that estate. The more value an estate has, the more assets in the estate, the more the probate fees might hurt the person making the will. Take an example of somebody who has a $5 million estate. The probate fees there would be $70,000. So if there are alternatives to be put into place in order to avoid probate, and those alternatives, or that estate plan that provides those alternatives, costs you $30,000 because you have a somewhat complicated estate, then you're still saving your estate and you're saving your heirs a lot of money by putting an alternative in place. So that is one major downside. The other major downside for a will is that a will is subject to variation from the court. And this is something which is fairly unique to British Columbia, but basically what Section 60 of our Wills, Estates and Succession Act provides is that if a will maker dies leaving a will that does not, in the court's opinion, make adequate provision for the proper maintenance and support of the will maker's spouse or his or her children, then the court may, in a proceeding by that spouse or the children, order that a provision that it thinks is adequate, just, and equitable in the circumstances be made out of the will maker's estate for the spouse or for the children. Now, that's the legal wording. What does that actually mean? In broad terms, it means that if the court looks at the will and decides that you as the will maker did not provide adequately and equitably for your children or for your spouse, it can rewrite the will and it can essentially take from you the control as to who gets what, and it can redistribute according to what the court thinks is fair. Who would be able to make a claim for wills variation? Well, that is quite specific. It's only your spouse or your children. Spouse, however, can mean many things. It doesn't necessarily mean just the legally married spouse, but it can also be someone with whom you're in a common law marriage or a spousal type relationship that has been going on for 2 years prior to death. But that doesn't even have to be consistent, as in 2 years concurrently or in a row prior to death, according to a recent BC Court of Appeal decision. And so the result of that is that there are possibilities for multiple spouses. There are possibilities that you could have 2 or 3 spouses all making claims for a will's variation against the will that you have prepared with much care. Your children can also claim, but only natural or adopted children would have standing to make a claim for will's variation. So that means that stepchildren or in loco parentis children that have not been adopted do not have claims against a will. That's especially important in British Columbia and generally across Canada, simply because we would see so many people having blended families. But in BC specifically, if you have a blended family and you leave everything to your second spouse, then your children from your first marriage would not be able to claim a will's variation against your second spouse as well in due course. So you would have to provide for them in your own will to avoid there being a will's variation claim being made against your will upon your death. And then the question is, if the court is able to, in so many ways, rewrite your will, how do you disinherit a person, a spouse or a child that you don't want to have benefit because for whatever reason they've disappointed you or you are not pleased with how they've been conducting themselves? In other words, how do you keep their hands off your money? And while we are able to provide some effective means in order to try and persuade and influence the court that you had valid reasons for disinheriting, those are not binding on the court. They are merely persuasive and informative. So the only way really to prevent a will's variation claim is to not have a will at all. But as Annie mentioned, that isn't necessarily a good idea. And in any event, even if you choose to go with an alternative estate plan that does not include a will, you should nevertheless consider alternatives to making a will so that you don't fall into an intestacy. But I believe that Annie will be touching on some of those later.
Now, one of the pieces during a pandemic is thinking about other tools that we can use if we get sick. Can you talk about an enduring power of attorney and why is it that people need one?
Sure. So an enduring power of attorney is essentially a legal document that allows you to appoint one or more persons to manage your financial and personal affairs in the event that you should lose your mental capacity. It allows that attorney that you've chosen to manage your finances, to pay your bills, to sell your properties if necessary, or to sell shares. Now, an enduring power of attorney subsists beyond the point where you lose capacity. whereas a regular power of attorney would terminate upon you losing capacity. So there is a distinction between the two. While you have capacity, even if your power of attorney is an enduring one, it immediately takes effect unless there is a springing provision. Now, while you still have capacity, your attorney would then act as your agent. But once you lose capacity, your attorney becomes your fiduciary and is therefore subject to far higher levels of scrutiny as to what they're doing because they're acting in a fiduciary role. But what you need to remember about an enduring power of attorney is that your attorney has the power to sell property and in all other respects deal with and access your finances as you would be able to. So it is incredibly important that when you pick an attorney, you pick the right person. While an attorney cannot make a will, the power of attorney allows for some additional estate planning, subject to certain conditions, such as, for example, an attorney would be able to make very limited gifts or loans from your estate, which would be limited to the lesser of 10% of your annual income or $5,000, whichever is the lesser. And also an attorney can, in certain circumstances and subject to some conditions, change beneficiary designation. So you shouldn't look at the power of attorney as being a substitution for your own obligation to put together an estate plan and to make a will, because your attorney will not have the authority under the power of attorney to take on that role on your behalf. Why should you have one? Great question. Well, quite frankly, if you don't have one, then your bank accounts are inaccessible. Nobody can pay your bills or pay for your care. And if, for example, your house has to be sold or important financial transactions have to take place, nobody is available who is authorized to make those decisions or to take those steps on your behalf. And you risk that your financial affairs will not be administered unless and until the court appoints a committee of affairs for you. Committee being a fancy legal word for legal guardian, essentially a court-appointed guardian who is able to act on your behalf. But if that were to happen, you would have no control over who the court appoints as your committee. And a committeeship takes time, and I'll deal with that a little bit later. But certainly a committeeship is sometimes contentious, it can take time, it's expensive, and it is easily avoided by you appointing the power of attorney of your choice. Who can be an attorney? Well, that can be anyone really who is over the age of 19. Usually you'll find it's a family member, but it can also be a professional such as a trust company. But here's the thing that everyone has to remember when they appoint a power of attorney. It has to be someone that you trust 100% completely and unconditionally. If you have any concerns about this person and you want to have a second attorney so that there's someone looking over their shoulder, I say appoint someone else. It's simply too risky to give that kind of power to someone where you have doubts about whether or not they're going to be acting in your best interests. The attorney, unless the power of attorney says otherwise, should also know that they're not entitled to remuneration for what they do, and they're not entitled to self-deal unless the power of attorney states otherwise. So self-dealing would be, for example, selling your house to themselves while using the power of attorney. To be valid, a power of attorney has to be executed by a person who has capacity at the time of making the power of attorney. So it's too late to try and make a power of attorney once capacity is gone, which is one of the reasons why we think it is a useful tool and an imperative tool to include in your estate planning while you have capacity, because it allows you to appoint that person who's going to act on your behalf. From a formal perspective, it is usually signed before a lawyer or notary and needs to be signed in front of 2 witnesses, although somewhat different rules now apply during COVID-19 because of social distancing and physical distancing requirements. And then the power of attorney also terminates when it is revoked by the donor, assuming the donor still has capacity. It terminates on the donor's death. It terminates on the attorney's death, bankruptcy, or the attorney's incapacity, and also where the attorney is convicted of certain criminal offenses. And then a committeeship order from the court or a certificate of incapacity that is issued by the public guardian and trustee of British Columbia would also similarly terminate the power of attorney.
Well, so many things to think about, and I'm sure Fasken guides their clients through all of these different options. But another thing I'm curious about, Eric, that I've been hearing about is during this pandemic, preparing for the future, is what is a healthcare representation agreement? And why do I need this?
Well, that's a great question. And this is another useful document that is usually prepared by lawyers as part and parcel of an estate plan. And even the simplest estate plan will usually consist of a will, of a power of attorney, and a representation agreement. The representation agreement is a so-called living will. It allows you to appoint one or more persons to manage limited financial affairs and your personal affairs in the event of your mental incapacity, and in the case of a specific type of representation agreement, to give end-of-life instructions or make decisions when you no longer can. Why should you have one? Well, if you don't, then there is nobody who can make that decision for you that you have nominated, and then it's possible that the healthcare system will look to a person under the Substitute Decision Makers Act to make the decisions on your behalf. And that may be someone that you did not want to have that right. But more importantly than that, it is someone that you don't necessarily want to give that authority to. It is someone that may not know what your wishes are. And so the most important thing about having a representation agreement is that you are able to not only appoint the person that you want to be making healthcare decisions on your behalf when the time comes, or when you no longer have capacity, but also someone with whom you can in advance discuss the kinds of decisions that you would want him or her to make on your behalf. Now, there are essentially two types of representation agreements. There are Section 7 representation agreements and Section 9 representation agreements, and they differ somewhat. In the case of a Section 7 agreement, the representative is authorized to make personal care and health care decisions on behalf of the adult making the representation agreement, but also entitled to make routine financial decisions and handle routine financial affairs. Don't confuse a Section 7 representation agreement with a power of attorney, though, because the ability of the representative to deal with your financial affairs is far more limited. And as the word routine financial affairs would suggest, it's really related to paying bills and perhaps collecting rent and things of that nature on your behalf. A Section 9 representation agreement is far broader in the sense that it allows the representative to make personal care and healthcare decisions, but also end-of-life decisions, which the Section 7 representation agreement does not. So if the decision has to be taken whether you should go into full-time care, if the decision has to be taken whether or not you should be taken off of ventilation in a hospital, for example, a Section 9 representation agreement would provide that authority, whereas a Section 7 representation agreement would not. I mentioned that it's important to pick the right representative. Who should it be? And again, that person has to be 19 years or older. They need to have capacity themselves. It should ideally be a family member or a close friend, but at the very least, it should be someone that you not only trust, but that you can have these difficult discussions with, as in, what do I want you to do in the event that the unforeseen or the unthinkable should happen? Because it's no point appointing someone as your representative and they are in the dark as to what you actually want to have happen. You can appoint the public guardian and trustee as your representative, or in some cases, a credit union or trust company to administer your routine financial affairs. But whoever you pick, it should be someone, like I said, that knows you and that will act in your best interests.
Sorry, go ahead.
Sorry. And so you should also bear in mind that the representative, just like the attorney, is not able to change or make a will for you. To be valid, though, a representation agreement, a Section 7 representation agreement can be made even after the adult has limited capacity. In other words, even if you are incapable of making a contract or managing your healthcare, personal care, or your legal matters, or the routine management of your financial affairs, you're still able to make a Section 7 representation agreement, which distinguishes it from the Section 9 agreement, where you must be capable of understanding the nature and consequences of the agreement, which means, in other words, you need to have capacity. And just like with the power of attorney, usually you'll have the representation agreement signed before a lawyer or notary in the presence of two unrelated adult witnesses. But you shouldn't do this just without seeking legal advice, because there's changes due to COVID-19 which are changing on a regular basis, but which do make some provision for the difficulties we're currently facing when it comes to social distancing. And then finally, the representation agreement terminates much like a power of attorney does when it is revoked by the adult, if the adult still has capacity, on the adult's death, where the adult becomes bankrupt or the representative becomes bankrupt, or where the adult is subject to the appointment of a receiver. The representative, in other words, the person that you've selected, if they die or cease to have capacity, then of course the representation agreement would also fail or would terminate. And therefore it's sometimes useful to have an alternate that you nominate as your representative just in the eventuality of that happening. The representative can also not be convicted of criminal offenses involving dishonesty and continue to serve as your representative. And then if it is a credit union or trust company, upon the dissolution or winding up or ceasing to carry on business by that credit union or trust company, the representation agreement terminates. And then lastly, the committeeship from a court or an order for committeeship of person by the court, which again is the legal guardian of the personal affairs that is authorized and ordered by the court, that immediately and automatically terminates the representation agreement.
As Eric was speaking, Annie, I was just so curious about another piece of the puzzle that I've been hearing about, and that's trusts. You know, what is that, a trust, and why do you need one in addition to all of these other items?
I think, so trust is something we get a lot of questions about because most people are generally familiar with or have heard about wills, powers of attorneys, representation agreements that Eric just went through. Now with trusts, that is, we generally, when we talk about trusts legally, there are two main types of trusts. So the first one is one that I already touched upon. So that's what we call testamentary trusts, or sort of what I describe to clients as inheritance trusts. So these are ones that we would set up in advance. The client set out the terms, and that's usually through a will, or sometimes if they want to do a life insurance declaration, if they have a life insurance policy they want to do a specific designation for, then that's where that would be created. And these trusts don't exist now. They only are created when that person passes away and there's assets that go through either the will or the life insurance proceeds that come out. Then those trusts exist, then they're set up for the beneficiaries of those assets. Now, if we're talking about testamentary trusts through a will, like I said, will is the simplest form of postmortem planning, but it may not always be the best option, right? Eric has gone through already some of the downsides of wills, having to pay probate fees of 1.4%, having the risk of wills variation challenges if there are spouses or children out there who are not happy with the proportion that they got through the will. So this is where we can talk to clients about the second type of trust. So the second type of trust is what we call inter vivos trusts. And these are all fancy legal terms, but inter vivos trust essentially is a trust that a client sets up now during their lifetime. It exists now, we would put assets in now. So inter vivos trust is very different because it exists now, we put assets in now. It's not by law considered a separate legal entity, but for all intents and purposes, it does act that way. It can own its own assets, and the assets that it owns is going to be separate from the individual, so the client themselves, anybody we appoint as beneficiaries or trustees. So in that case, we're essentially separating out these assets we're putting into this inter vivos trust from the client's own personal assets. And what does that mean? So it means that similar to what we would think about when we have a corporation, assets go into these inter vivos trusts. They're no longer the client's own personal assets. And so when the client passes away, these assets do not go through their will, do not go through their estate. And again, by that way, we can avoid probate fees and avoid wills variation challenges. Now with inter vivos trust, it's extremely important to get proper legal advice because it is a very complex area of law and especially of tax. When we set up these type of trusts, we do have to consider each client's own specific circumstances, who the beneficiaries are, what their objectives are. When we're doing estate planning for clients, there's a lot of different ways and options that we can do planning. And unfortunately, there is going to be no one perfect way that will exactly match every single objective the client wants. Every type of option will have its advantage and disadvantage, and of course, costs. And so each client will have to be aware of that and then pick the option that is best for them. Some clients will prefer and have, set more importance on asset protection for themselves or their beneficiaries. If they think they have, the gold digger son or daughter-in-law, so to speak, right? Or some other clients will be more focused on tax planning, tax efficiency. So those are going to be very different objectives, and we would achieve them through different types of trusts and structures. So we don't have time at all today to get into trust. We could have a whole day seminar on it, but I'm going to touch on a couple of different ones that clients might, or the attendees might want to think about. So the first one is what we call alter ego or joint partner trust. So these are a very specialized type of trust, and it's purely for estate planning purposes, for post-mortem planning. So in order to set up an alter ego or joint partner trust, the person does have to be a Canadian tax resident, and they do have to be over 65. So the difference between the two is alter ego trust is for one person, okay, and joint partner trust is for spouses, two spouses. So if it's spouses, if it's a joint partner trust, just one spouse has to be over 65. Okay. Now, these type of trusts, like I said, are purely for estate planning purposes. So from an income tax perspective, they're designed to be essentially tax neutral. So when assets are transferred into the trust, there is no deemed disposition. So normally when we transfer assets into a trust, we gift assets in, you're considered to have sold the assets to the trust at fair market value. If there is a capital gain on those assets, unrealized capital gain, that is going to be triggered right away, and capital gains taxes have to be paid. With this type of trust, there is no deemed disposition. When you put it in, there is no capital gains taxes. It's transferred in at cost. Okay. And so when do we pay these taxes? Well, when the asset is either sold or when the client, or if it's spouses, both spouses pass away. So the income tax effect is exactly the same as if you still held those assets personally. Okay. And in terms of income earned on that trust, it's the same thing. It's income tax neutral. So any income earned by an alter ego joint partner trust, all of that income goes back to the client or the spouses, and they pay taxes on their own personal tax return at their own personal rate. So exactly the same as if they still held it personally. So what's the benefit of these alter ego joint partner trusts? Well, they're a very simple way of doing estate planning. When these assets go into this alter ego or joint partner trust, it's separate, as I said, from the client's own personal assets. When they pass away, these assets do not have to go through probate. So you save the 1.4% probate fees, which can add up to quite a bit for clients, especially if we're talking about real estate being held in there. The other thing for this is, because it doesn't go through a will, it is not subject to any challenge by spouses or children, any wills variation challenge. And of course, without having to go through probate, makes it much easier and quicker for administration at the end of the day. And it allows for more privacy and confidentiality. When you go through a probate process with a will, everything does have to be public, and it is public record. Okay. So other two types of trusts I'll kind of mention quickly is, one is an income splitting trust. So these type of trusts are set up purely for tax efficiency. So if it's set up properly, it does allow clients who are in a higher income tax bracket to split income they may earn in that year with lower earning family members. Now, we used to do these with corporate shares. We no longer are able to do that. It's much more restricted with our new TOSI tax rules, but this is still possible with portfolios in non-corporate income. And we can talk a little bit more about that. The other types of trusts generally sort of group into family trusts. So these are where we can have them hold corporate shares. We often use them in corporate structures, or with other, like I said, partly income splitting trusts, or just purely trusts for asset protection for beneficiaries. So with these type of trusts, some of the advantages, the clients get to maintain control without having to gift assets directly to kids. They can avoid probate fees. They avoid the wills variation challenges that we mentioned. We often can build in asset protection. Again, we have the privacy, confidentiality. And then in some instances, depending on what assets go in these circumstances of the beneficiaries, often there can also be tax savings as well. Thanks.
So as we're looking at this pandemic, and we don't know what the second wave of the virus is going to look like, Annie, how does COVID-19 limit or affect a person's ability to make an estate plan, though?
Right, so it's a very good question. So with proper advice, COVID-19 doesn't actually have to affect anybody's ability to do planning. So when we're talking about some of the more basic planning, if we're talking about wills, we do have very stringent will signing requirements in BC. The wills does have to be signed in the presence of 2 adult witnesses. Those people do not have to be lawyers or notaries, but they cannot be people listed in the will as beneficiaries or spouses of beneficiaries. So often family members are not going to be proper witnesses. So we can still, and we still are doing wills for clients. When it comes to sign up, we have to take a look at the circumstances. If it's possible, we often will do what we sort of call drive-by signing. So we'll go pop over to a client's house, we'll sign outside because we find that that's the best way to still be able to do social distancing protocols. And so we can set up a little table or have something in the middle where the client signs, and then we can sign and they can step back and we can sign. So as long as we're all within the presence of each other, we can still maintain the social distancing protocol. So that's one way of doing things. Now, the other circumstance is where perhaps the person is under mandatory quarantine, or we have had clients that have tested positive for COVID-19, in which case we do want to be extremely careful. And so in those kind of situations, there's no way for us in BC right now to get around the stringent signing requirements. That has not been allowed here in BC, has been allowed in certain other provinces. But in BC, in our legislation, our Wills, Estates and Succession Act, there is a section 58, which allows us to go to court and allow the court to ask the court to essentially rectify a will or say a will is valid, even though it doesn't meet the formal signing requirements. So in particular for clients who are not able to meet with witnesses, it's unsafe for them to do so, we will do this. And so what we've done is we essentially will paperwork the will, include explanation of why we can't meet the stringent signing requirements, reference the section 58, and do essentially extra declarations. We might also do, web conferences with the client so that we can record that this is their final intention, just due to the extraordinary circumstances that they weren't able to meet the signing requirements. And so with all this, the idea is that if something does happen to the client, then we'll be able to go to court with all this evidence and be able to make sure that that will is going to be considered rectified and be considered valid. But the other key point for clients is we always tell them, once it's safe to do so, we do recommend that they do actually get it signed up properly so that there are no issues. And then the second thing is in terms of powers of attorney. So powers of attorney, Eric had mentioned, typically we do have them signed in front of an attorney, a lawyer or a notary. And again, because of the land title restrictions, we're not able to do that remotely. It does have to be in the presence of a lawyer or notary, so you do have to be physically in front of us. So again, we do sometimes do this for clients with social distancing protocols, signing outside in driveways, things like that. Now, where a power of attorney may not be needed for land title purposes, if the client doesn't own real estate, or they just want to get it in place, and they can do so signing again in front of 2 adult witnesses. So that works as well, right? So those are things that we can do. The other thing for powers of attorney, if it's not possible to get one done, for business owner clients, some of the other options may be to appoint additional directors so that you have additional people available to sign, have signing authority at the banks or sign documents, etc. So that's one thing that we do recommend for business owners, is to think about not just your own personal assets, but also your business assets, right? And then lastly, just to talk about the trust that we just mentioned, Vivos trust, setting those up. Those are much simpler to set up remotely than wills or powers of attorney. They do not need to be signed in front of a lawyer or notary. They can be signed remotely. And we do those signing by email, etc. But we do want to make sure we have proper documentation and everything done as well.
Well, I'm hearing that there's a lot of innovation already happening within the legal industry as a result of the pandemic, and I'm sure more to come. Another piece of the puzzle is related to planning. When do you need to start thinking about this? I'm a young person, or I have a young family with a couple of kids. Why do I need to worry about this? I'm healthy, or I'm not going to get the virus. What are some of the consequences, Eric, over to you, in terms of improper planning?
Thank you, Anita. I think you hit the nail on the head when you say a lot of people think they're young, or they put it aside because they'll deal with it later. And you'll be surprised to know that 60% of people in British Columbia don't have a will, which means that they've probably got no estate plan in place whatsoever. What are the consequences? And really, age is not a factor. You should have a plan in place as soon as you start having assets, as soon as you start having children, because it's really important that these kinds of risks are catered against. And what is the biggest risk if you don't have a plan in place? And it is a loss of control. You have absolutely no control once you have lost capacity or once you have died without an estate plan in place as to what is going to happen with regards to your estate or with regards to your assets while you're still alive. Taking as an example the will, if you don't have a will in place, then your assets will devolve by intestacy. Who will be the administrator? Is there going to be a dispute between your heirs as to the identity of that administrator because they may not get along? Annie mentioned earlier on, you can pick a guardian for your children. Well, if you don't have a will in place, then that is something that you haven't put into place either. And so there might be disputes about that. And that brings about delay, and it brings about costs, and it brings about litigation. Litigation is great for the litigation lawyers such as myself, but it's extremely costly. It's extremely harrowing for the people that are involved in it, and it can tear families apart and have really unintended and unforeseen consequences, which you don't want to put your children through simply because you've died, or alternatively, you don't want people fighting to get to court to get a committeeship order in order to be able to take decisions on your behalf. So when it comes to the delay and the costs, for example, if you don't have an enduring power of attorney in place, or you don't have a representation agreement in place, then if you were to lose capacity, there would have to be an application to court for a committeeship. Now, at present, the court is trying to roll with the punches, and it is making provisions for some matters to go to court, but most matters currently are adjourned indefinitely, and you cannot get into court unless you have a very simple or an extremely urgent matter. And so, for example, when it comes to committeeship, you can't get into court at present unless you have an emergency committeeship matter. Now, the court doesn't define what an emergency committeeship is, but certainly the question then would arise, what happens in the meantime? What happens until such time as you have a committeeship order? What happens to your financial affairs and your assets, and who can deal with those? And also, I mentioned that can be contentious. If an application for committeeship becomes contentious, it can take up to a year or two to be resolved, which again, it will not only escalate costs, but it will also create that vacuum as to what happens in the intervening period. So I think the major takeaway is a lack of estate plan can result, and probably usually does result, in litigation and disputes between your family members, which you can easily avoid by putting a plan in place, or a good plan, because just any old plan won't necessarily stop litigation. But some of the issues that could arise, for example, is issues regarding document authentication. There could be disputes about the authenticity of a will. There could be claims for will's variation. And again, as I've mentioned, these kinds of litigation matters take time, they cost a lot of money, and they are bad for family unity. I have one matter which has been going on for about 15 years since Mom died, and Dad died in 2010, and the family is still at it. They're still litigating, and they have spent a significant portion of what ultimately should have been their inheritance, their legacy, on litigation fees, which could have been avoided if the parents had put a plan together, had put a plan in place. But as it turns out, they both died interstate. So that's just a cautionary tale of what to avoid. Another unforeseen consequence of not having a proper estate plan in place is that there may be costs or taxes that you didn't realize would arise, and that could have been minimized with an effective estate plan in place. And so these are all factors that should be taken into consideration. But really the overarching risk in not having an estate plan is that you give up control. You put it in the hands of either the province, or you put it in the hands of the legislators who came up with the Wills, Estates and Succession Act, or you put it in control of whoever gets an order to administer your estate or to be your committee. And you may not want that. You may wish to not rule from the grave, but at least have the people that are taking the decisions on your behalf be those people that you think are fit for the purpose. I just want to end off on that point by saying that an estate planning tool should really reflect that individual person's wishes and circumstances, because it is intended not only to provide them with peace of mind, but also to guard against attack down the road. And really what we always try to make clear to our clients is that every estate plan really has to be somewhat unique, because nobody's circumstances, nobody's family relationships are all identical. And therefore, it is good to have a bespoke plan that is effective and fit for your specific purposes.
Annie, my final question is to you. Does the pandemic offer any planning opportunities for individuals?
Thanks, Anita. So absolutely. So the bright side of sort of COVID-19, the pandemic, is that it does afford a lot of planning opportunities for clients, and especially for business owners. Now, I know we're running short on time, so I don't have too much time to get into details, but for business owners, now would be extremely beneficial time to do what we call an estate freeze. So an estate freeze essentially allows us to freeze the current value of the company in the client's own hands, and then allow us to put in a corporate structure where we can essentially pass on the future growth and future gains of the company to usually a family trust or to the next generation. So what this allows clients to do is to defer these capital gains to the next generation, so they're not triggered when they pass away. There's no big tax bill to try to minimize that. The clients, if they use a family trust, are still able to maintain control of these future growth shares, so they can still decide what they want to do later on with the shares, who they want to pass it on to. And the other thing that this does is it reduces probate fees and challenges to the estate that we talked about before. It does afford creditor and asset protection to a certain degree. And why is this a planning opportunity now? It's because estate freezes are the best to do while business values are low. And that means that the lower the value, the better, because the lower the amount of the gains that will be in our client's hands. And so if we do it now with a business at low value, it means that once the business comes back and it's back up and running, then all of those gains will be pushed to the next generation. And through these type of things, we can, if clients are considering later on doing a sale, by putting in a family trust, we can also potentially multiply the lifetime capital gains exemption if they qualify, if their business qualifies. And that is approximately $860,000 or so per person. That is tax-free upon the sale of qualified small business shares. So through a family trust, a client might be able to defer all these gains to this trust and then put in a bunch of family members they may have who are eligible. And once they sell the shares in the future of this trust, all of those shares will be able to take advantage of each particular family member's $860,000 capital gains exemption. So that can be a huge amount. So this is also the time where we are looking at client structures and seeing if there's ways that we can simplify structures or take advantages of losses in particular entities, matching them with where other companies may still be having a profit, try and match it so that there's some tax savings there as well. So that, and then the other things, other potential opportunities are if clients have real estate investment holdings personally, while the values are low, this might also be a good idea for us, good time for us to roll them into companies. So similar to that estate freeze concept that we just talked about. So future growth on these real estate investments will now be transferred to next generation. We're deferring those capital gains on to the next generation. It's not triggered at the time of passing. We're reducing probate fees. We're providing asset protection, but still control for the clients and all those sort of fun stuff. The last thing I'm going to talk a little bit about is income splitting. So kind of stepping aside from the corporate planning, if clients have cash or investment portfolios and they personally themselves are at a high income level, we can set up, there are ways to do income splitting with lower income family members. Now this have to be set up properly because there are lots of rules in our income tax act that doesn't allow us to do income splitting very easily, but there are ways that we can legitimately and legally do this. So first is a spousal loan. So you can do a loan from the higher income earning spouse to the lower income earning spouse. It does have to be a loan with a prescribed rate of interest. So you do have to charge interest to your spouse. And the best part of that is that the interest rate is actually quite low. And the government has recently announced that the rate that they've set is actually going to go down. Currently it is 2%, but as of July 1st, it's going to be 1%. So high income spouse loans money to low income spouse, charges 1% interest. So that 1% interest does have to be paid. The higher income spouse does have to pay tax on that 1%. But whatever additional income is earned on that portfolio, so if their portfolio has income 6%, the extra 5% of income will be paid at the lower income earning spouse's tax rate. So that could be quite a bit. And so besides the spousal loan, though, we do have additional opportunities to do income splitting through family trusts. So it's the same kind of scenario, same kind of structure, but instead of a loan between spouses, we do a loan to a family trust. And in doing so, we can actually also split income with minor children. Adult children as well, but minor children are the best because typically they have no other income. So they are very, very tax efficient to do it that way as well. So with COVID-19, with portfolios being at lower values, this is actually a very good time to set up this type of planning for the future and for tax savings.
Well, thank you so much, Annie and Eric. Just such a wealth of experience from the law firm of Fasken. Thank you again for joining us at the Surrey Board of Trade Surrey Digital Town Hall this morning. Thank you to the Port of Vancouver for their sponsorship. The session is recorded, ladies and gentlemen, and we will send the link to you. And you need to be thinking about the future, and you need good partners to do that. Thank you again for joining us. Remember to visit the Surrey Pandemic Business Center at businessinsurrey.com.